Good morning, everyone. Thank you for being here with us. I know there's so many things that you all could be doing today, so we appreciate you taking some time out of your busy schedules. I'm really excited to be here with you all, and welcome to our 2025 legislative update presentation.
Thank you, Anastasia. As Kathy mentioned, this training is supported by grant funds from the Office of Violence Against Women, and no federal grant dollars were used for lobbying. So we're going to go ahead and get started with just a little bit. Hopefully you all know about CCASA as you're here to join us, but the Colorado Coalition Against Sexual Assault, we are a membership organization serving the state, made up of members who are those of you who provide services to survivors, sexual assault programs, service providers, and survivors themselves. And so this wide range of perspectives helps us inform our policy agenda and our work to advance anti-sexual violence, the anti-sexual violence movement. And CCASA offers support, leadership, and advocacy to improve survivors' experiences and the way that we address sexual violence in our state, and also the prevention of sexual violence. So that's a little bit about us. Me specifically, I'm Elizabeth Newman. I use she, her pronouns, and I am the public policy director at CCASA. I've been with CCASA for 4 years. And my job is to bring the voice of our diverse membership and a survivor-centered perspective to decision-making tables. And that includes our policy work as well as systems change efforts. So I develop and advocate for legislation. I work with my colleagues to strategize for systems change and public affairs. And then I also do consultation, training, and technical assistance for our members and partners to support their understanding and implementation of policies and potential legislation.
Thanks, Elizabeth. Hi, everyone. I'm Anastasia Cole, and my pronouns are she, her. I'm CCASA's Policy and Outreach Manager, and I've been privileged to be with the organization for about 2 years now. In my role, I make up the other half of our small but mighty policy team of two. And in my role, I really support all things legislation, development, and advocacy. I also work on identifying amendments and orbital bills and trying to find ways to ensure that survivors' needs and perspectives are addressed in intersecting areas. One of the things I'm really focused in on my role is outreach and helping inform and engage our members throughout the year. I have the honor to oversee and manage our policy committee, where we, as Elizabeth spoke to, come together and help identify our policy priorities every year and make sure that our positions and our strategies are informed not only by survivors' lived experiences and stories, but also the issues that our members see with boots on the ground. In my role, I also have the privilege to oversee CCASA's Survivor Task Force, which is a group of survivors in Colorado who want to share their stories and experiences to affect change. And like Elizabeth, I also provide training and technical assistance throughout the year to help folks like yourselves understand new laws as they're passed and how they impact the work that you all do. So today we have a busy agenda, try to keep us on track. But before we jump into it, I did want to just take a minute to just get a feel for who's in our audience today. So Kathy's going to launch a quick poll. If you would just take a second to fill out what professional background you're coming from. That's really helpful for us as we develop these trainings to make sure that we are providing the most relevant information for everyone here. So just give it a minute, have everyone fill that
Hello.
out.
Is that Lolly? Who's that? I see.
All of it, it sounds like you're came off mute, just so you know.
Sorry, guys.
No problem. Happens all the time. All right, looks like we're getting pretty close. Another second. As we're filling it out, just a quick overview. So today we're going to spend the first chunk of our presentation talking about 2025 state policy changes. We'll cover some important civil and criminal protections and also some other protections in various areas. Then we will spend quite a bit of time talking about the sexual assault evidence kit backlog and where we go from here.
Okay, it looks like we have 44% community-based advocates, 4% systems-based advocates, 4% restorative justice, 6% SANES, 2% law enforcement, 2% campus advocates, and that looks like it. Thanks so much for participating.
Thank you, Kathy, and thank you everyone for filling that out. All right, I think we're ready to go to the next slide. Perfect. So before we jump into it today, just wanted to give you all a quick high-level overview of the 2025 legislative session. Up here, you can see some information about how many bills we tracked, supported, and testified on. Did want to mention that this year was, as Kathy mentioned earlier, was very tough due to our $1.5 billion budget deficit. And despite that budget deficit, the legislative session was still very busy from start to finish. Overall, there were 657 bills introduced, and of those, 585, or roughly 90% of those bills passed. So again, throughout that process of those 657, we were actively involved in tracking 36. We actively supported 26, testified on 16, and supported 8 survivors in sharing their stories. Then I'm going to kick it over to Elizabeth to get us started. I'm talking about our priority bills that all have a common theme of increasing access, accountability, and protections for survivors. So I'll pass it off to Elizabeth to get us started.
Thank you, Anastasia. The first bill we're going to go into here is a change to the Civil Rape Shield law. Rape Shield laws, for those who are not familiar, were created to help protect survivors' privacy and to disrupt the humiliation that they often face in the legal process. And starting in 1977, Colorado passed its first Rape Shield law in the criminal cases, and then expanded those protections to civil cases. And later in 2024, the Colorado District Attorney's Council expanded the criminal Rape Shield law. And this year in 2025, we worked with the Colorado Women's Bar Association to pass House Bill 1138 to protect victims in civil sexual misconduct suits. So this bill aims to eliminate some of those biases and stereotypes that are harmful to survivors and the fairness in their legal process, and to ensure that the things that are irrelevant are not introduced into the case. And so this law specifically restricts any evidence about a survivor's sexual history with the defendant. Already their sexual history with other individuals was prohibited from being introduced in a court case. And this then brings in their sexual history with the defendant specifically, or with the individual who's alleged to have committed the offense, as well as information about their clothing, their hair, their appearance, or any kind of manner of speech, so that that's not used as evidence of their consent, their credibility, or even how much they experienced harm in civil sexual assault cases. We know that so many times survivors behave in ways that are counterintuitive, that are not what someone would think that how they should behave. And that is due to a whole number of factors. There is no one perfect way to respond when someone's experienced sexual violence. However, these assumptions and these stereotypes about how someone should act or behave are often brought into these cases as evidence that they weren't harmed or that the harm wasn't serious enough. And so this law now says that in order for any of those types of evidence to be introduced into the case, there has to be a preliminary hearing to demonstrate that that actually is relevant. It has to overcome a presumption of irrelevance, meaning it's assumed that it is not relevant to the case. It doesn't have a role in there unless they can prove that before a judge. It also prevents invasive pretrial questions ahead of a trial in the discovery phase or in pretrial. There can be lines of questioning. We heard about a workplace sexual harassment case where the opposing counsel was inquiring about how many different fathers the victim's children had. And so these types of questions are irrelevant to the case at hand, and this prevents them from being asked and further traumatizing survivors through the legal process. This bill passed with large bipartisan support, and you can see capture of the vote count there in our image. It passed actually in March, and it went into effect July 1st. So for any cases that start before or on or after July 1st, this new law and these protections will be in place. The second bill we brought forward this year relates to parental protections, and House Bill 1185 works to address some gaps from protections that were established more than 10 years ago. We learned from our members and survivors that they had tried to access this right to petition, so to ask the courts to terminate the parental rights of their assailant, and had faced closed doors, had been, clerks were not willing to accept these cases, were confused about this process. And so no one in Colorado had successfully been able to use this law that we were aware of. And so we passed House Bill 1185 to address that gap in implementation. So the process is already in place. As we said, this was a right established more than 10 years ago. What we have going forward is the requirement for the courts to have a new form or an updated form by January 1st of this next year, so that they have to accept and hear each petition filed in the juvenile court to request a hearing that would rule on whether or not the assailant's parental rights should be terminated. This is really just giving survivors an opportunity to ensure that they are not legally tied to the person who harmed them. We know that so often people who want to cause harm may use the legal system and the court process to help facilitate that by filing filing for custody or things like that when they maybe haven't had a reason to otherwise engage with the child that resulted from a sexual assault. And so again, this is a process. These are rights that already exist. We just are making it more accessible. While we worked on this issue, we were inspired to expand these protections by a case from a survivor who became pregnant at 19 from a rape and had no family support. She was unable to access abortion or adoption. And so she did give her rights to the assailant. She voluntarily relinquished that child, but she was forced to provide child support for 18 years because that legal parental responsibility was still tied to her, even though she had no relationship, no custody, no rights to the child otherwise. And so she really wanted to make this change so that no one else would ever have to go through that. And we expanded this law to include now a process for survivors who want to voluntarily give up their rights to a child, so that they can, in that process, inform the courts that the child was a result of a sexual assault, and therefore if that's found to be accurate, if the court finds evidence of that, they would be exempted from counseling, court fees, and child support. So these pieces ensure that that burden of sexual assault and that burden of a forced pregnancy are enough that someone shouldn't have to continue to carry those burdens for the whole child's life or for another 18 years. We were really grateful to our sponsors here in the House who ensured that this bill passed unanimously. And while it might only help a small number of survivors, we know that it makes a huge difference for them to be able to access these processes. Before we move on, we are going to just take a quick pause for questions on this these two bills before we shift to another set of topics. Do we have any questions so far?
I don't see any questions in the chat, but everyone, go ahead and drop your questions. Leanna says, thank you for addressing this gap.
Great. Well, we will also have time at the end for additional questions. So if something comes to you or you want to ask information later on, we'll also provide our email addresses. And just to note, the new form and the new is required by January 1st. The relinquishment process is effective August 5th, and the parental rights termination process is already effective because that was already in place. Okay. Anastasia.
Thanks, Elizabeth. All right, before we dive into the next topic, wanted to take a minute or two to launch a couple of polls. We just are hoping to gauge how much you all are seeing housing issues intersect with your advocacy for survivors. And so thank you, Kathy, for launching our first poll. It reads, how often do housing issues affect the survivors you serve? The options are frequently, sometimes, rarely, never, or not applicable. So just take a minute or so to give folks a chance to fill that out. So far, it's looking like frequently is the leading answer, just certainly in alignment with what we've heard on the ground. Looks like we're at 75% of folks answered, so we'll just give it a couple more seconds. All right. Looks like we have a couple answers still coming in. All right, well, it definitely looks like frequently is the leader with 57% of folks who have answered saying frequently, 20% indicating sometimes, 2% indicating rarely, 0% indicating never, and 20% indicating not applicable. Thank you for filling that out. And then as a quick follow-up to that, we have one other one, and this is going to be for folks who did indicate that this housing issues come up in their work. What type of housing issues most commonly affect the survivors you serve? So we have eviction history, breaking a lease, securing new housing, affordability, eviction threats, or safety concerns. So again, I'll just take a quick minute to give folks a chance to fill that out before we move on. All right, thank you all for participating. Looks like there's quite a variety here. So far, we have about 62% of folks who have participated in the poll. And as of that, we have 27% of folks list eviction history, 48% is breaking a lease, 80% securing new housing, 89% for affordability, 36 for eviction threats, and 57% for safety concerns. Thank you all for filling that out. That's definitely in alignment with what we've heard, and definitely makes me even more excited to share this next bill with you all.
Anastasia, we have a couple of comments. One, all of those, but my clients deal with regularly, but 4 and 6 the most. So affordability and safety concerns. And also, I also checked all of them. Every aspect of housing and safety is an issue. And oh, 4 of them, I'm sorry, Alex said 4 of the 6th.
Wow.
So there, 4 of the 6 are just huge. And
Yeah,
housing and safety are big issues for everyone.
absolutely. Thank you, Alex. Thank you, Leanne. I appreciate that. All right. So just as a quick disclaimer, heads up, this is a bigger bill. There's a lot to cover here. So we're going to have break this into 2 slides. And then happy to answer any questions that folks have. We'll start off by saying I am not a housing attorney, and we were very excited to see this bill come forward. So House Bill 1168 was led and introduced by our partners at the Colorado Poverty Law Project and the Colorado Coalition for the Homeless. This bill does a lot of things, but the central theme is increasing housing protections for victim survivors. One of the things that we learned early on in this process is that a lot of the existing eviction and lease breaking protections in Colorado have primarily applied to survivors of domestic violence and domestic abuse. And survivors of sexual violence and stalking have historically been excluded from some of those protections. So just from the top, one of the biggest things that this does is really expand eviction protections to survivors of sexual violence and stalking to help address that disparity. Another big thing that this does is it really expands the type of allowable documentation to make these protections more accessible and to help remove barriers for folks. Previously, I believe, from my understanding, that the only types of allowable documentation were going to be from a police report or a protection order. And while those are still types of allowable documentation, we know that both of those things can pose barriers to survivors for various reasons. Many folks are not in a place where they want to report to law enforcement or not in a place where they choose to do so. And protection orders, while we have done a lot of work to make them more accessible, certainly can still pose financial barriers and make things more difficult for folks, especially in a time of crisis. And so we were very excited to see that this bill expands the type of allowable documentation to include a self-attestation affidavit and or a third party statement from a qualified third party. And this can include anyone from a community-based victim advocate to a mental health professional or another professional who is familiar with the survivor situation and can speak to the fact that what they have experienced has had an impact in their life and therefore an impact on their housing situation. We know that a lot of folks, especially in the immediate aftermath of experiencing sexual violence, struggle with anything from physical effects to mental health, with performing at work, things like that. There's so many reasons that a survivor might fall behind on rent or might choose to relocate. And so expanding this type of allowable documentation really helps remove those barriers and help make it easier for survivors to access these things. I do want to mention that in terms of the allowable documentation, the bill does specify that the survivor must provide the name of the responsible party, but it does say that they're only required to do so, one, if that information is known, and two, if it is safe to do so. So, if a survivor did not know they're the perpetrator, that obviously would not be applicable, or if it was determined that it was not safe to share that information, let's say, for example, in a domestic violence situation, they would not be required to, but then in any other circumstances, they would be asked to do that. And then one other thing to mention is with the self-attestation piece. The only other caveat to that is if for some reason a landlord receives conflicting information after receiving a self-attestation affidavit, they can require one additional form of verification through that letter from a qualified third party. So let's say that a victim survivor provided a statement, certifying that they are a victim survivor, explaining their situation. And let's say they heard some sort of conflicting information from a roommate or a neighbor, they could then go require that extra form of documentation. But again, recognizing that that can include a community-based victim advocate or a mental health professional, we're still supportive of that and know that it will help increase that access.
Anastasia, the interpreter asked that you slow down a little bit, please.
Thank you. Yes, I will try my best. I appreciate that reminder. The other thing I wanted to mention is around security deposit protections. So we know a lot of times, especially with domestic violence cases, that there can be harm caused to the property, and in many cases, survivors end up being financially responsible for those damages, and in some cases will have their security deposit withheld. With this bill, it does specify that if the physical harm to the property has been caused by the responsible or the responsible party, that the victim survivor is not going to be liable for those physical damages. The bill does specify, however, that landlords are still able to seek those damages from the responsible party. And I think that that really ties back to the piece that I mentioned a second ago around the requirement to provide the name of the responsible party if it is available and if it is safe to do so, so that landlords can still go through that process to seek that compensation to fix their property and prepare it for the next tenants. And then finally, on this piece, this bill does also make it easier to suppress eviction court records. We know that having an eviction record can pose a lot of barriers, not only for survivors, but just folks broadly. And when you are trying to secure housing in the future, if you have that on your record, it can make it a lot more difficult to secure housing and to have a landlord be willing to rent to you. And so under this bill, any person who is documented victim survivor can request to have, if they have gone through an eviction case, they can request to have those records suppressed. Unfortunately, that's not something that's automatically done, but wanted to make you all aware of that so that the survivors that you're working with, if they have been impacted or are impacted with something like this in the future, that they have the ability to request to have those eviction records suppressed. And that covers everything for this piece. Drink some water and take a deep breath so I can help slow down. All right. So a couple of other important things that I wanted to mention. A really big thing that this bill focuses on is really helping prevent evictions by requiring landlords to offer a repayment plan. We know, as I mentioned, that there are so many ways that survivors are impacted by the violence that they've experienced. And it's very common for folks to fall behind on rent. And so under this bill, it does require landlords to offer victim survivors who have documented that, who have provided those types of documentation that we just discussed, requires them to offer a repayment plan. Originally, this was 12 months, but it was negotiated down to 9 months. So that's as long as that repayment plan can be. And as it says on the slides, they have 3 business days to offer that plan to survivors. The survivors then have 7 days to accept. And the minimum payment is going to be required to be at least $25. However, I think in most cases, considering the cost of living, it's very likely going to be higher than that, but that is what the bill set as the standard for a minimum payment. And then again, late payments will be required to be made within 10 days. And I do want to just mention that this repayment plan does not indicate that survivors do not have to pay rent going forward. There is going to be a predetermined time that this repayment plan would apply to. So this is not saying that, if they have 3 months on their lease left, that they do not have to pay for month 2 and 3. This is just going to apply to the time period and the rent that they have fallen behind on. That is directly related to their experience. And then finally, and was happy to see, well, I shouldn't say happy, but thought it was interesting to see everyone's responses in terms of some of these areas, but specifically the safety measures. As we were looking at this bill, we saw an opportunity to help increase survivor safety, recognizing that different people have different needs. Some people, choose that they want to relocate and break their lease. But a lot of people end up staying, whether that is through choice or out of necessity. And increasing that safety is so important. So under this bill, it really explicitly allows victim survivors to install what they determine or define as reasonable safety measures. And that includes anything from new locks and security cameras to window bars and things in that category. And I just want to mention that it does specifically say that they're allowed to do this without landlord interference or retaliation. The only thing to mention is if they do opt to change the lock, so they are going to be required to, of course, provide the landlord with a copy of that lock. The only exception to that would be if the landlord themselves is the responsible party. And then, of course, in that case, they would not be required to do so. And this passed in May, on May 22nd, and is now in effect.
Anastasia, we have a couple of questions. JD asks if this is an eviction defense, meaning survivor may have to show up to court and share the self-declaration letter or attestation from qualified individual. Will this be an option for parents if their child is a victim of sexual assault?
That is a great question. Let me read it one more time.
Okay.
Okay, to the first piece of the question, yes, this can be used as an eviction defense in court. In terms of if this would be an option for parents if their child is a victim of sexual assault, I believe so. Elizabeth, I don't know if you have any thoughts on that. I would assume that's the case, but that is not something that's come up so far. So really good question. Elizabeth, do you have any thoughts on that?
Yeah, I would add that the protection is for the victim survivor, and if the victim survivor is living with their family, and the family would be able to, I'm 95% sure, would be able to then assert those rights, assuming that they would have some type of documentation or things. I think it would be difficult, and we would definitely encourage people to consult with housing attorneys when they have cases or want more technical assistance. And we do have individuals who we can put you in touch with if you want to just ask some of these questions more deeply. But yes, the housing protections would cover a minor, which then would extend to the parent under criminal law. They would be considered part of the victim.
Thank you. And Vanessa asks, if law enforcement officers damage property during the apprehension of the offender, for example, SWAT response damages, walls, floors, would that be considered damage by offender ultimately and be applicable to the security deposit protection? Or is there any protection for survivors in that situation?
Yes, I'm happy to answer that. The law states that the victim survivor is not liable for damage caused by the responsible party or during the course of an incident. And so law enforcement response would be could be argued to be part of during the course of an incident. and the responsibility of the offending party. Some of these rights might need to be argued. However, a lot of this is something that, just putting into notice and informing the landlord of these rights can be accessible. So it really will depend on how much, you'd have to push the landlord on it, but some of these can be just articulated that this damage occurred during the course of the incident.
Great.
That's great questions, everyone. Before we move on, does anyone else have any questions about this bill that you'd like us to try to address before we switch gears a little bit? All right, I'm not seeing any, so I think we're okay to move on, but if anything comes up, please feel free to put it in the chat, and then once we have a break, we're happy to address some of those things. And we do have some amazing housing attorneys in our network, so if we can't answer any questions, we're happy to check in with them and follow up after this webinar. All right. Now we're gonna get talking about AI misuse. Just a quick disclaimer, this is also another big bill. We're gonna split it up into 3 slides, and I will do my best to slow down and take some breaths to help our amazing interpreters. All right, so Senate Bill 288 really addresses a lot of the misuse that we're seeing with AI deepfakes. Last year, we worked on Senate Bill 11 that made some updates to our intimate image abuse statutes, but this bill really builds on some of that progress that we established last year and helps really modernize Colorado's laws to keep up with developments in AI. I would say this bill is unique in the sense that it does tackle both civil and criminal updates. A lot of times with legislation, you will see bills that only apply to either the civil or criminal side of things, but this does address both. And so we're going to start with the civil. I'll cover the criminal side of things, and then Elizabeth will finish us out talking about some of the really important updates to the child sexual exploitation material statutes. So on the civil side of things, the biggest thing that Senate Bill 288 does is it creates a new civil cause of action for non-consensual disclosure or threat of disclosure of an intimate image or intimate digital depiction. That term, intimate digital depiction, is defined in the bill. I won't bore you all with it, but it is there if you're interested in taking a look at how that is defined. I do want to highlight, and it is here on the slide, but just emphasize the fact that under this civil cause of action, someone does not actually need to disclose this image non-consensually. It does apply to threatening to disclose. So we know that in a lot of cases, sexual deepfakes have been used for harassment and blackmail. And so if someone does threaten to disclose a non-consensual image, this civil cause of action would still apply. And just like with any civil cause of action, there's a couple of standards in order for it to apply. One, of course, the person who is filing the claim or filing the suit needs to have actually suffered some form of harm. And they also need to show that there was a reckless disregard for a couple of things. So one is they need to have shown reckless disregard for that the knowledge that the person did not consent to the image being disclosed. They need to they need to show reckless disregard for a severe emotional distress. So knowing that this disclosure would cause severe emotional distress for the survivor, and then also reckless disregard for whether the depicted person would be able to be identified. I think it's really important to mention that just because someone has consented to the creation of an image does not mean that they have consented to that image being disclosed. And so this bill does specifically outline that even if a person has consented to someone making, an image or video for them or in general, that does not mean that they have consented for the latter. And so if someone has consented under this bill, it does outline that consent must be specific and in writing. So if they have consented to the image being created and disclosed, there needs to be, and this is outlined in the bill, but overall, there needs to be some sort of written disclosure outlining what circumstances and situations the person is consenting to that image to be disclosed in. So for example, a person could write out and say, I consent to this image being disclosed in, let's say a video game. That does then not give that other person permission to then go and disclose that image online, or let's say like in an anime or something like that. The written agreement needs to specifically outline what circumstances they are consenting to. And of course, it does also say that that written agreement needs to be signed by the depicted person willingly and not under any coercion. I also want to mention that there are a couple of exemptions to this. There's a good faith reporting and public interest exemption. So if you as an individual were, reporting a violation of this, or if you were called to testify in court, you would of course not be held liable for that. And then the other thing is with public interest. I do want to mention though, I think the biggest area of public interest that often comes up is with elected leaders and politicians. And this bill does specify that just because the depicted person is an elected official does not automatically mean that it's a public interest, that it is within the public interest. And so that is not going to be an automatic defense. And then additionally, also wanted to mention that in some cases, we've seen cases where an image has like a little box on the bottom that says, the person depicted in this did not consent to this, image or video. This bill does specifically outline that that is not a defense. It doesn't matter if you disclose that this was non-consensual. It is still illegal and it is still, able to have accountability in the civil cause of action. And then finally, on the civil side of things, just want to mention that this does provide some additional privacy protections for survivors in court. First of all, it allows survivors in these civil cases to use a pseudonym to protect their privacy. It also authorizes the court to allow camera proceedings so they don't have to attend court in person. And then finally, it just kind of leaves things open and suggests that the court can make other orders as needed to protect the survivor's privacy in general. And this bill passed on June 2nd, and it goes into effect here shortly, just in about a week from now, on August 5th. And that is going to apply to all of this section and all of the sections that we will talk about on this bill. All right, I think we're ready to move to the criminal side. All right. So building on that, a lot of these updates for the criminal side of things is going to be similar to what we just covered for civil. So again, this is going to apply to non-consensual disclosure or threat of disclosure of an intimate digital depiction. I do want to mention that this bill does not create any new crimes. However, it does expand existing crimes to include AI deepfakes in these intimate digital depictions. So overall, just in general, and for the policy nerds here who are interested in looking, I did include the Colorado revised statute references that these updates were made in if you're interested in taking a look. But overall, this crime is going to be considered a level 1 misdemeanor. There can be heightened penalties, and it can be raised to a class 6 felony if the actor or the person causing harm knew that disclosing this intimate image posed an imminent and serious threat to the person themselves or their family and their family's safety. So in those cases, that would have that heightened penalty, but for most cases, that's going to be considered a level 1 misdemeanor. In terms of how they identify these cases, it really comes down to intent. And what's listed in here really applies to which crime is being pursued. So as it shows here on our first bullet point, these crimes are limited to harassment or monetary gain. It's actually called pecuniary gain. And, we have a lot of discussions with folks of, how can posting an intimate image of someone not be considered harassment or monetary gain? And I certainly feel similarly, and that is how our statutes are written. So those are going to be the cases that are able to be pursued in the criminal legal side of things. So when it comes down to determining how these cases are applied, it really depends on which crime is being pursued. So, for example, if someone is being charged with non-consensual disclosure or threat for harassment, the intent is going to need they're going to need to show the intention to either harass, intimidate, or coerce. Or if they can't or they choose not to, or knowledge that the survivor had a reasonable expectation to privacy and that actual harm was caused. And again, the type of harm caused is going to be related to the crime that's being charged. So for harassment, they would need to show that there was some sort of harm, whether that was physical, emotional, or reputational. And then same with the pecuniary side of things, they will need to show that they have the intention to financially benefit, or that they had the knowledge that, the survivor had a reasonable expectation of privacy and the knowledge that this would cause financial harm to the depicted person. Also want to mention that just like on the civil side of things, just having a disclosure at the bottom that says that this was a non-consensually created image or video is not an eligible defense under this law, and it has similar exemptions to civil. And so it does not have the public interest exemption, but it does have the good faith law enforcement exemption. So again, if you saw an image on the internet or someone shared something to you and you took that and reported it to law enforcement, of course you are not going to be held liable under this. And likewise, if you're called to testify in court or in some sort of official legal proceeding, you're not going to have to worry about being charged under this statute. And again, like I mentioned, this is going into effect here shortly in just about a week or so. I think I'll pass it over to Elizabeth to finish us out and talk about some of our CSEM statute updates.
Thanks, Anastasia. And as Anastasia mentioned, these are not new crimes that were created or even really the civil remedy. This is expanding what are already crimes and to incorporate the new technology. So we're just catching up our statutes with the new reality of the advancing AI technology. So the other two pieces that this law expanded were the teen sexting statute. So that is created so that young people who might be consensually sharing images, intimate images, are not charged with CSEM or child pornography charges. And so that was a bill that was passed several years ago. And this act just changes that offense of posting, possessing, or exchanging a private image by a juvenile to disclosing, possessing, or exchanging a private intimate image or intimate digital depiction by a juvenile. So penalties remain the same. The level of it remains the same. It just changes to incorporate these digital depictions, as Anastasia mentioned, by computer or computer generated or digital alterations. Secondly, the bill updates the sexual exploitation of a minor statute, which is considered our CSEM or child pornography statutes. Again, this is not changing the type of crime it is or the penalties. It is expanding it to ensure that realistic visual depictions of children engaged in sexually exploitive situations or exposing private parts are also captured under this law. So sexually exploitative material now includes these realistic visual depictions created, altered, or produced by digitation or computer-generated means, and that is for possession, creation, or distribution. All of those are captured here. Again, not a defense to claim that you didn't know or that it was created using digital or computer-generated means. The key pieces here, we're really getting into the weeds on this, are that the individual in question, so someone could create some type of AI CSAM that does not have an identifiable child, and that would not be captured here. So again, there has to be some kind of way to identify a child and who's there. They don't have to say who exactly it is, but there have to be things that are identifiable, like a certain birthmark or a certain type of feature. The second thing is that it has to be a child when the image was created, the original image that's then used. So there can be CSAM that's created from images that are of a child who's now an adult that would still be classified under this law. However, taking an image of an adult and de-aging them would not fall under this. So again, there's a real tight line that the legal teams on both the defense and prosecution side had to figure out, because this technology is rapidly evolving and can do so many different things, to say at what point someone becomes charged with a criminal offense. Okay. One other bill affecting sort of children and youth that we want to highlight is House Bill 1188, which updated the mandatory reporting requirements based on the task force's recommendations. So this bill came from a bill originally proposed in 2022, which would have updated mandatory reporting requirements. And there was a lot of stakeholdering conversation that needed to happen with different parties to really get to some of these questions around the over policing and surveillance of communities of color and under-resourced communities, as well as questions about how mandatory reporting and the child welfare system can cause harm to families, and the intersection with domestic violence, sexual violence, and mandatory reporting. So a task force was created that met for 2 years to look at all of these different issues and put together a full list of recommendations, which some of them cost money, and so therefore they were not incorporated into this bill given our budget situation. But some of the things that were changed related to the mandatory reporting requirements for different occupations and then the process for making those reports. So specifically, community-based confidential victim advocates were removed as mandated reporters. Those are folks who have been trained and work or volunteer as an advocate at a community-based domestic violence or sexual assault program. These are not system-based, so law enforcement or district attorney advocates. These are specific to providing services and support for victims and survivors of domestic and sexual violence, and those who have been trained to do that work, as well as their supervisors, so those who work there. That means that because they are confidential and they're no longer required to report, that in fact they may not make a report to child welfare, to the police, unless the victim survivor wants to, so without their consent. For those other professions, and I wanted to say quickly, this is something that the vast majority of other states allow. So Colorado was one of only 7 that states and DC that had victim advocates, community-based, confidential victim advocates required to report suspected child abuse and neglect. Advocates do not report for individuals with disabilities or for at-risk adults, elderly. That is something that they're still a confidential resource for, and advocates are trained to help victims and survivors navigate and understand their options to report to another mandated reporter. No other professions were removed from the list except for social workers under the under a law attorney team. So legal, they have that legal privilege there as well. Again, this is bringing us in line with the vast majority of other states and ensuring that survivors have access to that support and that safety first and foremost, so that they can then take those next steps in terms of how to report and those types of things. So they can still talk to teachers, medical providers, therapists, all of those other individuals to share this information and incur or report themselves or a family member, anyone else who might be able to make that report. For those other professions who are mandatory reporters, there were a couple pieces clarified in this law. First being that a report must be made within 24 hours. Previously, it just said immediately, and there was not a timeline laid out, so that that definition was unclear, and folks followed their own interpretation of it. Now it's very clear that the reports must be made within 24 hours. That reports are required specifically for incidents that are where someone witnesses or gets information about suspected or confirmed child abuse or neglect during their professional capacity. So a teacher who is at the grocery store is not wearing their mandatory reporter hat. They're not required to report everything that they might see. And then lastly, it limits delegation. So only those individuals who have the firsthand knowledge are the ones to make the report. If multiple people witness or have the same information, only one of them must make a report. However, you cannot delegate your mandatory reporting responsibility to another individual who does not have that information. And then the law also clarified that, again, these reports are for suspected or known child abuse and neglect. They cannot be based on race, ethnicity, socioeconomic status, or disability. A family being homeless is not child abuse. There's an encouragement from even on the risk screening side for those who receive reports to start to look more deeply at what are the conditions and whether or not this is really just a family that needs support and resources. Poverty is not child abuse. So there were these really tough conversations held with the task force to find that line of where there's a need for system engagement that may possibly remove children from their family of origin or the family that's providing care for them, and to really take that seriously, because that is a trauma that happens to a family and can also expose that child to further abuse within the system. And so these changes are based on 2 years of these conversations and work supported by the majority of task force members. The vast majority of these changes went into effect when the bill was signed on May 31st. So all of these pieces listed on this slide here. There are some changes on the implementation side for the Department of Human Services that are going into effect September 1st. And then guidance is in progress. CCASA has held a webinar with our colleagues at Violence Free Colorado and our other partners on implementing this change for advocates. And we are working on additional resources in the meantime, but this change is now in effect. Okay. So again, we're going to pause for questions and Any comments before we move on?
We have a question that says, does this apply to duty to warn as well? If someone tells you they're going to kill or harm someone immediately and has a plan and the means, or does that exception to confidentiality remain? For example, DV offender calls hotline and says they're going to kill their partner, has a plan and a gun.
So this bill specifically changed things as it relates to child abuse and neglect mandatory reporting requirements. However, our understanding is that confidentiality already covered duty to warn, that there was not a requirement to warn for those types of threats. That is certainly something that someone might have to make an individual call for, but the confidentiality requirement is within the program based on your funding through the Federal Violence Against Women Act and Victims of Crime Act, which mandate confidentiality for personally identifying information and confidentiality of victims. And then the privilege piece is specifically for advocates. So there's a layer of privacy, privilege, confidentiality, and privilege that this just makes sure that that exemption specifically on child abuse and neglect is not actually applying in Colorado anymore. So I hope that answers your question. I do want to encourage folks who are wanting to get deeper into the specific application to your program or your the staff who work for you to engage legal counsel. We are not lawyers, so we're letting you know what the law says and how that may apply. But if you want to get into specifics on your program or the staff who work for you, we do encourage consultation with legal counsel.
Elizabeth, we have one more question in the chat. It says, how should we handle if we hear a minor tell us they've already told a mandatory or mandated reporter, a teacher, for example, and they didn't report it?
Yeah, so as an advocate, if someone is coming to you and letting you know how systems have failed you, that's a great way for advocates to help support that victim survivor in navigating next steps and what they might want to do, whether they want to speak to another mandated reporter, whether they want to file a complaint against that mandated reporter for failure to comply. These are the types of conversations and ways that you can support survivors in figuring out what their next steps are. We come from a frame that empowers survivors and says that they are the experts in their own experience and that we should really look to them to see what their vision for safety and healing and justice is and help them achieve that. So I do encourage, thank you, Kathy, folks who have these types of questions and want to talk through them to come to our office hours, which are on Fridays at 12 to 1 via Zoom. You can pop in anytime for the next couple months and talk through these types of scenarios and get feedback from our training and technical assistance team. Anastasia and I are not advocates. We have not been trained in that. We are public policy professionals. And so I don't want to speak too much on how to apply this in specific situations. Thank you for the very good questions, though. So moving along, we did want to highlight another issue that became a primary focus in this legislative session, which is related to the sexual assault evidence kit backlog. Many of you might have seen in the news, the backlog became public in January as a survivor bravely came forward and testified before the Joint Judiciary Committee about the incredible agony of waiting more than 400 days for the results of their evidence to be processed. This launched some strong media coverage and support from the legislature to resolve this issue. Currently, as part of their response to this problem, the Colorado Bureau of Investigations has started to publicly share the number of kits in the backlog. And so for July, currently we are looking at 1,236 sexual assault evidence kits waiting for processing. And on average, it is taking 570 days as of July 10th for these kits to be turned around. That is a slight increase in time. I do want to note that CBI turnaround time, instead of an average, which would be the middle number, they actually share the 80th percentile. So of the cases in the previous 3 months, 80% of them were completed in this time or less. And that's the way that they feel like it's more accurate, because they don't want to give someone hope that if you're at the middle 50%, that might apply to you. And so they are sharing that information. They have set a 90-day turnaround goal, and they're estimating to be down to a 220-day turnaround time by January 2026. All of this work has been mostly focused on the state crime lab, which is within CBI. However, other local and regional labs have had some challenges with meeting the turnaround time for sexual assault evidence kits as well. And this legislative response is mostly focused on CBI, but does expand that view a little bit more. So with this, these changes, we did see a couple things happen. One was funding to invest heavily in outsourcing kits to have them processed more expeditiously. And so Senate Bill 170 provided some of that funding by allowing CBI to use money that they had not yet spent to outsource kits. They also had to start publishing this data and put forward a dashboard that shared the data and estimated when they would turn around and reduce the timeline for processing kits. House Bill 1275 looked at lab integrity. One of the factors that contributed to the current sexual assault evidence kit backlog was misconduct by a forensic scientist who had a long career, and when their misconduct and the deleting or misrepresenting of results became known in November 2023, led to CBI having to review all of their past cases. And that's part of why this backlog ballooned. It was already increasing due to staffing issues, but this then really redirected all of their resources to looking backwards and checking these kits or evidence that had been studied by a forensic scientist. And so that lab integrity bill requires that lab employees report misconduct that they might witness or suspect within 14 days, and ensures that victims and defendants are notified if their case is impacted. And then we'll talk a little bit more about Senate Bill 304 in a minute.
Just wanted to take a quick second to highlight our sexual assault evidence kit backlog town hall that we co-hosted at the Capitol back in March. Through this event, we were able to bring over 120 people in person and online to the Capitol, or to engage in this conversation, to really continue to highlight and bring attention to this issue, but also to give survivors and advocates a space to share their stories, ask questions, and really demand more from our elected officials and the offices that have been involved in this issue. This really highlighted the power of us coming together in community, the power of leaning into lived experience expertise, which is so important, and also led to some really important ongoing commitments, both from our legislative branch and from CBI, as Elizabeth will highlight as she talks about Senate Bill 304.
Thanks, Anastasia. None of this would have been possible without the push of this broader community, but really the spark that was created by Miranda Gordon. And so we were really proud that Senate Bill 304 was named after her, the Miranda Gordon Justice for Survivors Act, which does a number of things, but really pushes our state to look at this issue more from a bigger picture, that this is not just about one lab failing to keep up with the number of kits coming in, that the problems in responding to sexual violence for those who choose to report are broad and really significant and harmful. And so this bill creates a permanent sexual assault forensic medical review board, which is really to look at the system response and improve the survivors' experiences as they go through collection of evidence, possible reporting through law enforcement, district attorney process of charging a case, and the court process of trying it, and even potentially after that into probation or parole and those types of systems. So this overall view of the whole system response is going to be housed under the Attorney General's office and include representatives from advocacy, medical systems, and law enforcement, among others, our state programs, and really to look at a number of issues regarding our practices, policies, and training. The bill also set up a goal of a 60-day turnaround time, and you'll know that is very different from where we are currently at 570 days. The legislature, unfortunately, did not provide any resources to move labs closer to that turnaround time, nor did they provide any consequences if there's a failure to do so. But they really wanted to push labs to be more ambitious and to be more considerate of what is a humane amount of time to make someone wait for results. What we brought to the attention of the legislature is that they're not just waiting for their results to come in. That's really pausing an investigation. They're waiting for anything, nothing else really moves until those kits come back. And so this last piece of this bill that's important to highlight is that it requires law enforcement, for those survivors who are reporting to law enforcement, to notify any victim whose results have not been processed yet, at least every 90 days. One of the challenges we saw is that we have expanded survivors' access to know the status and have a right to know the status of their kit. And if their kit is just it hasn't changed status, it's just being held and it's not moving forward, they're not getting any update. There is no update for 570 days. And so this puts it on law enforcement to make sure that they're aware of that. And so that they're also thinking about how many survivors are just waiting for their evidence to be processed. Because of fiscal impacts, it does allow for there to be a bulk notification. So for those of you who are advocates or might be working with folks who have reported to law enforcement and are waiting for their kit to be returned, it allows for a single communication to go out to all survivors who are waiting the first week of each month that fall in March, June, September, and December. That way they can kind of capture everyone at one time, and it eases the administrative burden of having to monitor as soon as someone's kit reaches 90 days. I will say that we have now in effect the kit tracking system, which we passed in 2023. That does allow for law enforcement agencies and our systems to have better insight into where kits are and how many days they've been there. Prior to this, they would have to call labs to get those dates. And they still might have to, engage through the system. But this will give better information to survivors, to law enforcement, and to labs to move them faster along this evidence process. Okay. I know we took questions along the way. We do want to give time for questions. And while you're thinking of those, would love to have Anastasia talk about the ways that people can get involved in CCASA's policy work.
Thanks, Elizabeth. I know we're getting close to time, but just wanted to encourage everyone to consider getting involved with CCASA's policy work. We have several really meaningful opportunities available. One, just want to highlight again the Survivor Task Force. As I mentioned in my introduction, I oversee that group and really work with survivors one-on-one to help them share their stories and experiences to affect change. That can look a lot of different ways. And I'd say we're primarily focused on storytelling, testifying at the Capitol, and doing media interviews. Also, just want to mention that a lot of those things can be done anonymously, recognizing that a lot of survivors do not feel comfortable being publicly identified, but still want to share their stories and try to affect some sort of change. And so in our next slide, we'll have our email, but I can also drop the Survivor Task Force application link in. So encourage you, whether it's yourself or someone, a survivor that you know that is looking for these types of opportunities, really highly encourage you to reach out and share that information. We'd love to continue helping to support more survivors, share their voices and their stories at the Capitol and where all of these really important decisions are made. And then also we are in our open recruitment period for our policy committee. So if anyone who is involved or interested, please feel free to reach out to me. I will mention that our policy committee is limited to CCASA members. And so if you're not a member, but you're interested, that would be a prerequisite to joining. But our policy committee is really a critical part of helping to form our policy agenda and helping support our policy work throughout the year. And then even if those two opportunities don't sound like a right fit for you, I would really highly encourage you all to sign up for our newsletter and keep an eye out for our action alerts. Throughout the legislative session, we do send out action alerts related to the bills that we're working on, but throughout the fall, we will continue to send out action alerts related to funding and know how important it is for our elected leaders to hear from advocates and folks with boots on the ground that are seeing the real impacts of funding cuts. So if you're not on our newsletter yet, please feel free to sign up and share those action alerts with your network. Just want to say thank you so much. That is the end of our presentation today. Elizabeth and I's contact information is listed here. Again, if you all have questions or thoughts or feedback, please feel free to reach out. Or if you're interested in engaging with our policy work in any of the ways that I just discussed, please email us, and we hope to hear from you all soon. Thank you for your time today.
Thank you all for coming. I have dropped the evaluation in the chat, and you will also receive it in an email along with the slides. And as I said earlier, the slides will be sent out to you, and the video will be up on our YouTube channel later this week. And the evaluations are really important to us, that if you could fill those out and give us any ideas you might want to see in future webinars. And I also dropped the Become a Member link in the chat box. So we'd love to have you as members if you aren't already. Thank you again and have a wonderful week.